Okay, well, welcome everybody. At this time, I'd like to call the meeting to order. Today is Thursday, April 9th, 2026, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. We would like to begin by acknowledging that the land on which we gather, currently known as the City of West Hollywood, is the occupied, unceded, seized territory of the Gabrielino Tongva and Gabrielino Quiche peoples. At this point, I'm going to ask everyone who can to please rise and we'll do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. And Madam Secretary, may we have a roll call?
Commissioner Bass?
Here.
Commissioner Copeland?
Here.
Commissioner Kerpes?
Here.
Commissioner McCafferty?
Here.
Commissioner Topchin?
Here.
Vice Chair Goldman?
Here.
And Chair Rory?
Here. So we have a quorum, and now we'll move on to the approval of tonight's agenda. We have 2 appeals on the agenda and a presentation. With that, I'll move to approve. Is there a second?
Second.
Okay. All in favor, please say aye.
Aye.
Any opposed? No? All right, so that one agenda is approved. Now we'll do the same process for the minutes. We're going to be looking over the minutes from our last meeting, which was March 26th. Give people a chance to look those over.
I'll move it as presented.
Second.
And motion a second. All in favor?
Aye.
Any opposed? Okay, great. So we have an agenda, we have approval of minutes, and now we're going to move on to public comment. We do have one speaker, I think, this evening who'd like to speak at this time. It's 3 minutes. So, Mr. Kyle Braziel, if you could, you can only speak once under public comment, and the 3 minutes are yours.
Right, thank you. I'll try to keep my comments brief given the agenda items you have before you tonight, but wanted to introduce myself, Kyle Brazil, resident of West Hollywood. I've been going around to different commissions and advisory boards throughout the city because I'll be running for city council this fall. I think the work that you all do is central in any election in West Hollywood, right? Housing affordability is a key voter issue. It impacts our residents. It's personal to me. When I first moved to West Hollywood, I first moved to LA and lived downtown. It was not the community I wanted to be in. I wanted to be in West Hollywood, but it seemed out of reach. After searching, I was able to find an apartment that I could make work within my budget. I had to move my couch one way to get in the door and the other way to get into the fridge, but it was West Hollywood, so I was in the community I wanted to be in. I've also seen other issues with rentals, right? I've had landlords that treated security deposits like part of their personal bank account. I actually sued a landlord of mine in the past. I've yet to recover the money that I won in small claims court, but these issues around housing affordability and renter protections are important and crucial, and they're personal to me. So I think this commission in particular has insights that are relevant to the elections this year. I'll reach out to get to know you all personally over the coming weeks and months, but just wanted to, again, come by, introduce myself. Thank you for your service on this commission, and say I look forward to getting to know you all. Thank you.
Thank you, Mr. Brazil. Okay, so that's our only public speaker for right now. And we're going to then move on to our manager's report. So we're going to have our fearless Ms. Rollins lead us in a report.
Good evening, Commission. For the record, I'm Leona Rollins, and I am the Rent Stabilization Manager for the city. And we're going to be looking at our look-ahead calendar. So for this evening, we'll be hearing 2 appeals. The first one being D-5050, followed by appeal D-5087. It will then have a presentation on our calendar year 2025 rent stabilization and code enforcement update. At our next scheduled meeting on April 23rd, we will also have an appeal, which is D5081. We did receive appeal applications from both the property owner as well as the tenant, and we'll be also providing you with evaluation guidelines ad hoc subcommittee updates. At the following meeting, May 14th, we'll have 2 appeals that evening as well, which is D5063 and D5077. And we're also going to be welcoming our Human Services Division, who will be providing a presentation on the services and resources that they provide to the community at large. And our following meeting will be in the month of June, on June 11th, where we'll have an appeal, which is D5043 CD1, which will be based on a compliance determination. And that is our look-ahead calendar for this evening. Thank you.
Fantastic. Do we have any questions at this point for staff? Okay, maybe later. So with that, we can move on to the appeal portion of tonight's agenda. The first appeal we're going to do is D-5050. This is the property at 966 North San Vicente Boulevard. We're going to do a quick report from legal counsel, and then we will begin the hearing process. So with that, I will have our counsel take it away.
Great. Thank you, Chair. My name is Kellen Martz, legal counsel for the Rent Stabilization Commission. As the chair noted, this is D-5050. The property address here is 966 North San Vicente Boulevard. In this case, the appeal was filed by the tenant. And there are 2 issues before you on this appeal. The first is a reduction in housing services issue, and the second is a retention of rent in excess of what is permitted by law. The tenant has lived at the property since August of 1992. It's relevant here to note that the tenant filed a rent decrease application in 2024 for D-4966. In that matter, the hearing examiner found that the tenant was not entitled to a rent decrease related to access to outdoor water. The tenant appealed, stating that was an error. However, the commission heard the matter and affirmed the hearing examiner's decision. The resolution was as to 2 issues: outdoor water access and unauthorized access to the tenant's unit. The staff report in D-4966 specifically stated that landscaping and plants were not an issue before the commission at the time. It was just outdoor water access. Bringing us to the present application, on June 9th, 2025, the tenant applied for a rent decrease application. Again, it's for landscaping and trash can walkway cleanliness in the common area and rent overcharge. A hearing was held on the matter in July 2025. Both parties appeared either by themselves or through an attorney. As to the common area cleanliness issue, no common area tenants opted out, so they are all included in the common area determination here. The tenant testified that the gardener only blows the debris away but doesn't actually clean it, doesn't maintain the plants and landscaping, and doesn't water the walkways or trash cans. The decision does not indicate if landlord testified as to this issue. As to the rent overcharge issue, this was not greatly discussed by the hearing examiner, but they did state that there was no evidence that the tenant had paid, and the landlord accepted rent in excess of the currently established MAR. The decision on the landscaping and trash can cleanliness issue found that they were a little bit dusty, but they were still within permissible standards, and so the application was denied in full. Here, the tenant filed an appeal. As to the landscaping and trash can cleanliness issues, there's not much in the appeal, but they did include a copy of their lease, which requires that the tenants are required to keep the premises clean and in good condition. That includes keeping the garbage clean and neat. To reiterate, in D-4966, the previous case, the tenant was found not to have met the burden to establish that outdoor water access was a housing service or that it was removed by the landlord. But here the application is for cleanliness and tidiness of walkways, garbage cans, and plants. And so there are separate issues than what were presented in D-4966. As to the rent overcharge issue, the tenant's appeal argues that the hearing examiner didn't correctly review the rent and missed rent overcharge issues from 1991 to 2000. There were various documents provided in the appeal from communications with the Rent Stabilization Department of the City of West Hollywood. Oh, getting through it, folks. All right. So the questions before you tonight, bringing us to the commission, are: first, is there substantial evidence in the record to reasonably support the decision regarding landscaping and trash can walkway cleanliness? And second, is there substantial evidence to support the hearing examiner's decision regarding the rent overcharge issue? As to the first issue, the landscaping and cleanliness outdoor area issue, staff believes that the hearing examiner erred and recommends a reversal for that issue. Staff believes that the hearing examiner correctly ruled on the rent or overcharge issue and that there is substantial evidence in the record to support the decision on that matter. As to the landscaping issue, again, these are different issues in D4966 from staff's perspective. Then I want to note also the issue in the staff report about the 6-month filing of the appeal. This was filed within that 6-month window, so there needs to be an exception for them to file within that window. Here, staff believes, and as the tenant stated, that the exception is the grounds upon which applicant seeks a rent adjustment could not have been raised in the prior application. It's a little bit wonky, but these issues were not available because the commission hadn't ruled on those issues at that time. So their understanding of the issues were different, and then when the commission ruled on D4966, it changed the analysis for the tenant and the facts of the matter, and those were not available at the time that they filed their application. Based on the photos and the evidence in the record, staff believes that there is substantial evidence that the landscaping, pots, etc., are housing service for tenant and other common area tenants, and that there's substantial evidence of record that they were not maintained. And as to the rent overcharge issue, the statute of limitations does not allow to look back to the time period in which the tenant has claimed that there were rent overcharge issues, which is what the regulations and the municipal code require. And so even though it wasn't analyzed that way by the hearing examiner, they didn't actually state their reasoning, staff believes that that was the correct result, even though it wasn't explained that way, but that's how staff has analyzed it. And that concludes my report.
That was a kind of a process one. A lot of history in this appeal. I kind of have a question, but it's almost blurs into deliberation. But I still want to ask it because it's the part that I don't quite get. The exception for the 6-month filing window trips me. Could you just explain how the exception works, not as applied to the facts of this case, but just on a more theoretical level? Because it sounds like there's an exception if the issue that you're saying was a reduction in housing service couldn't be raised previously. And so my understanding of that for any type of appeal would be if it was an issue that existed previously and you could have raised it, that wouldn't fall within the exception. It has to be something that for whatever reason you really couldn't have raised it at the previous hearing. And I want to make sure that that's my understanding is correct, and whatever other guidance you can provide on that, because that trips me up.
Absolutely. This one's a little bit funky, I'll admit that. Staff takes a bit broader understanding of that, and I can read the actual language. The exception that we're discussing here is A, the grounds upon which applicant seeks a rent adjustment could not have been raised in the prior application. And so you could look at it two ways. Theoretically, did this problem exist when the prior application was filed? From a high-level answer, it did. But staff's reading of this is that, one, there's a policy argument. We want cases to be heard before the commission. And so the way we analyzed this was that it was the commission's resolution that changed the facts that were present. So his original argument was that I don't have outdoor water access, and that is how I clean these things and whatnot. So he could have raised that in the prior application, but it wasn't until the commission ruled that his understanding of how to do this was incorrect. And so it is a little funky there, but I think it fits within the exception enough that it could go forward.
Okay, that helps for the time being. I'm sure we'll get into it. Any other questions?
Can I ask a follow-up on that?
Yeah, please.
Chair, thank you. I didn't notice that the hearing examiner addressed the 6-month issue, nor was it on the application, the 6-month issue. So How do we apply if it wasn't discussed as part of the decision or application, the 6-month rule?
Yeah, so that was just something that staff noticed and put into the discussion because it was filed, and so you would, because this is a de novo topic as opposed to a factual finding, you're looking at it anew. So you are able to. It doesn't really matter that the hearing examiner missed it. I mean, they should have analyzed that, but you're looking at that brand new, so you can deliberate how you want on that topic.
Thank you.
You're welcome.
I think that's a good point to raise too, that the interpretation of the exception is one of those legal issues that is got that different standard. And just so everyone knows, we got a little refresher on the different standards for legal question versus fact question. I did have one quick follow-up, and I think Commissioner Kirby's might have a question too, I saw. For this appeal, as we're talking about standards, the appeal itself only checked one of the boxes for the basis of the appeal. It was A, the determination is clearly in error. So, and there are other bases you could do. B is not reasonably supported, C is abuse of discretion, D is contrary to specific provisions. When an appeal checks only one box, clearly in error, how, if at all, does that impact our analysis of the fact issues? Are we looking at whether the fact issues were clearly in error because that's the only box that was checked? Or are we doing the reasonably supported standard even if that box wasn't checked?
We're gonna always want to do the reasonably supported, because if it's not there, then there's not a case to be had. And so even though that's their argument, we're always wanting to look and make sure that there is substantial evidence in the record.
Okay. So regardless of what box gets checked on the appeal, we're always going to do reasonably supported standard?
Yes. The other ones we won't necessarily do, but that is a legal requirement that there's substantial evidence in the record, so we always need to make sure that that's
It's
there.
like a default.
Yeah, that's a commission requirement almost, as opposed to just a checkbox
Okay.
on the appeal.
Commissioner Kerpes, I don't know if you still
Yeah,
want
thank
to
you.
ask.
Yeah, I have questions about staff's determination that the hearing examiner erred in, did they err in their description of what they're seeing in the pictures? Or what facts
Yes.
are
So
not correct?
yeah, so staff believes that the interpretation of the evidence was incorrect, that there is a reduction in housing services for what was complained of, that no reasonable person could have found that they were not a housing service and not reduced in this situation.
So you don't think that there's enough evidence in there, that the hearing examiner didn't have enough evidence to claim that it was dusty and no dead things, but it was, kind of disheveled, but it was organized. It wasn't clean or wasn't dirty in terms of like messy, or however he described it. You're saying that that's not his observation is not enough evidence to support that?
Yes, that's staff's suggestion here, is that this one was, for staff to recommend overturning on something like that, has to be a clear error. It has to be, the ball has to be 9 feet out of the strike zone, not close. And so that's what staff is saying here, is that.
So I guess then tell me how it's nine yards out of the, tell me why this is a substantial difference.
The evidence of the record to staff appears to show that there was a substantial reduction in housing services. The hearing examiner found that there was not a reduction in those services. So it's just a disagreement, but it has to be an extreme disagreement for staff to recommend overturning it. So that's for deliberations if you agree or not with staff, but that's what staff recommended here.
Thank you.
You're welcome.
Commissioner Topshin, yes.
Hi, good evening, Mr. Martz. Hello. Regarding the rent overcharge, the whole focus is on the actual overcharge that the examiner concluded there was no evidence of or evidence of payments or overpayments. Was there at any point any discussion about the MAR, what the MAR should be as of now?
There was not. So in this case, this I think you can tell the decision was pretty sparse. And so we're not working with the best of records here that we sometimes see in other decisions. And so we have enough for the case to have been found and for it to proceed here, but we don't have a lot of information on that.
Right. So my concern is if there is possible overcharge and if there is a more increased above what the legal would be permitted, could we recommend on this particular item, the waiver of that 6-month period so the tenant can come back with the necessary evidence and to refile for the overcharges and determination of the MAR?
Yes, you could. And commissioners ask that, and I always say that's an exception to the rules, and so we have to be very sparse with using that. I think this case is a good example of that,
Okay.
if you would like, because we don't really know. It's almost as if the hearing examiner, is leading us to need to do that. So I think it would be okay in this case.
All right. Thank you very much. That's all.
You're welcome.
Okay, great. So now we'll move on to the hearing part. And since the tenant filed this appeal, the tenant gets to go first, and there's going to be a 5-minute window for them to speak. They'll get up to 5 minutes. Whatever time they don't use automatically goes to the rebuttal. And so after the tenant, then we'll hear from the landlord, and if there's time left, back to the tenant on the rebuttal.
Sorry, Chair, the tenant's not here today.
Oh, the tenant isn't here. Okay. So we're just going to be hearing from the landlord? Okay.
From the representative.
And is that Mr. I can see him conferring up here. Mr. William? Yes. Okay, why don't you come up to the microphone, sir? And then state your full name and who you're representing. And then you just get 5 minutes straight up, no rebuttal. So this is your shot once you start going to say what you want to say. We're focused on the issues that council was explaining. So if you can, try to stay within that framework. The other stuff is not going to be germane to what we're talking about tonight.
Understood. I do have one question.
Okay.
The landlord just asked me if they can say a couple words also with me. Is that possible?
Yeah, actually, we usually just, whatever they want to say has got to go through you. I like to have one speaker per side. It's just a fairness issue.
Can I step over to them for a quick
Yeah, go
second?
ahead and get it all in because you get your 5 minutes. Yeah. Oh, yeah. It's possessed. All right, sir, you ready?
Before I begin, they want me to say some specific things. You said to stay on topic. They want me to say certain specific things, so I'm just going to get that out first, and then I'll get into the topics that are germane.
Okay,
It'll be very
it's
quick, though.
your 5 minutes.
Okay.
It begins now.
All right. So, good evening. Thank you for having us.
Could you say your full name for the
My name is
record?
William Bogdoyan, and I represent the landlord.
Perfect.
At this hearing. So the landlord wanted me to communicate to you guys that the water issue has been an issue because the tenant has continuously left the water running overnight carelessly, with no regard to any of the bills that might be created because of the water. He's continuously forgotten to turn off the water overnight, and that's why this whole debacle began. Not only that, using the water, the tenant has sprayed the gentleman sitting over there a couple times. So he's attacked the gentleman over there with the water a couple times also. So that's what they wanted me to let you know. Now, regarding this hearing, D5050, I believe, I provided photos of the premises showing how clean it is. I provided that last week, not during the hearing, because I didn't have any of the evidence that the tenant was going to bring to the hearing, so I didn't know what the actual rebuttal needed to be. Every week, a gardener comes and cleans the property. Those images have been provided. Whether you would like to take that into consideration or not, it is your prerogative. The property is kept clean through an outside service as required, which is a gardener. This issue, as was discussed previously, should have been raised previously. So whether the tenant's understanding of how the process works was correct or incorrect, allowing the tenant to continuously bring these issues every few months is unduly prejudicial to the landlord. The undue prejudice is actually shown expressly because today even, the tenant texted me and literally said that this inept handyman created the problem at Ursula's expense, the landlord, and the handyman being that gentleman there. If they, being the panel here today, reverses the 30-day reduction, that he's going to file another complaint again regarding water usage. So essentially, he's telling me that until he gets exactly what he wants, he's going to keep filing claims and complaints to intimidate, harass, and pressure the landlord to bending to his will. That's not what this process is for. It's not to create a living hell for my client to get what he wants. That's not what this is. There's ample evidence that there's no habitability issues. The unit is clean. In the evidence that he showed, it was leaves from the trees that had fallen onto the walkway and some dust on the trash bins, which are cleaned every week. So this is not the Huntington Park Gardens where it's kept nice and tidy and perfectly shaped and manicured every day. This is a residential property. Every week someone comes, a gardener, and cleans the property. In addition, the current rent is $590, astonishingly low for the area. It's practically free. And he's continuously asking for rent reductions and rent overcharge allegations. It's clear that it's just going to be, until a stance is taken against the tenant's harassing behavior against my client, he's just going to continue shooting off these complaints, dragging my clients here every few months. So it is clear from the record that a reasonable fact finder would have found what the hearing examiner found, which is there's no grounds for any type of adjustment in rent. There's no clear error. Any reasonable person would find that the issues that he complained of are not rent adjustment worthy. So if there's any questions, I can respond.
All right, thank you, Mr. Bedoyan. Do we have any questions at this point? Okay, well, let's wait. Can we ask the witness first?
Well, it depends on what the answer is from staff. The pictures those were provided by the tenant, correct? The ones that we have right now?
That is correct.
Yeah, that's all I need.
There was late submitted photos that were not provided to you because they're new evidence.
So have you had an opportunity to see the pictures in the packet that we have? The
Yes.
packet that was provided to you?
Yes.
Would you say that those pictures are typical of what the property looks like?
No.
No. They are not? So which ones stand out to you that would not be?
There's a paper copy of the packet in front of you, sir, and Commissioner Kurbries, if you want to guide him.
It would be starting on page.
Yeah, in that book, he's going to give you some page numbers to look at.
I think it's, oh shoot. It's page 96.
8 and
I'm
96?
sorry, 96. Actually starts at 93.
We're starting here?
Yes, exactly. So that, if you could just flip to those pictures real quickly and tell me which ones are not a representative of the property on a normal basis.
The garbage can, the first page.
Okay. What about
I
page
would say
98?
It's 91. So page 91, not typical.
What about page 98?
Oh, page 98 you want me to look at? No, that is not typical.
Okay.
That might accumulate on maybe the 6th or 7th day because it's tree lined.
Okay. Thank
So
you.
when a gardener comes, cleans that, and then it ends up looking like the evidence that I provided.
I understand. Thank you. That's all I have.
And even in page, let's say 101, it's not nearly what it is on page 98. On page 90.
What do you mean it's not nearly what it is? 101?
I'm sorry?
I-
101.
Uh-huh.
That walkway looks nothing like the page on
On the
98.
previous one that we just looked
Yes.
at? Yeah, I
The
understand.
walkway on page 91, 2, 3, 93 doesn't look like the page, doesn't look like the walkway on 98.
Thank you.
Okay, any other questions for the witness? Go ahead, Commissioner McCafferty.
Just missed a couple of photos. I think there's
Oh, the faces.
some on 75.
75?
Yeah, there's like a group of, you can figure out what it is when you get there.
This?
Yeah, that group of photos.
Just this one? Or
The section of them. There's a few.
those are, I guess, bricks with some leaves that fell from the trees that are there. And again, that might accumulate over the week, and then
I think it's exemplifying what I assume is pet waste. Is that typical? Who has a dog? Is it a dog? What's happening?
are you referring to that as pet waste?
Yeah.
I don't know if I would say that's pet waste, but I don't know of anyone on the property that has pets.
No one on the property has pets?
Not that I know of, no.
Okay, well, the lease says that there's at least cats on the property and in the pictures. So I mean, I guess the point is that this group of photos from page 75 to, what is it, 79 is exemplifying, yeah, like, you know,
Oh, I see
a state
that.
of pet waste
I see.
on the property.
I see that one, yes. Let's say, regardless, even if it is pet waste, that is the responsibility of whoever pet that is to pick up and throw away.
But
You
there's
don't-
no pets on the property.
Not that I know of. But I think there was a cat in one of these pictures.
Okay.
So, like I said, it's not, I don't think that has anything to do with a hose issue. That was a right of usage of a hose to clean
This
up.
appeal does not have anything to do with the hose.
Okay.
So
Agreed.
that's fine. It's just about the cleanliness of the landscape.
But that cleanliness is what I'm saying is not the landlord's duty to clean someone else's pet's waste. That's what I'm saying.
Okay.
So even if there is waste there, if it's any of the tenants, then if anything, it's cause of action to evict those tenants because they're not keeping the unit clean of, the premises clean of their pet's waste on the property.
My questions are answered. Thank you.
Thank you.
All right, Commissioner Tobin.
Chair, yeah, thank you. Good evening, sir.
Thank you.
Question, so once a week on On what day of the week the service is being provided?
I can find out for you, but for sure there is once a week. Either on
It's always the same day?
I can find out for you.
Okay.
But I've been told there's every single week, at least once a week, there's a gardener that comes and cleans the premises.
Okay. And if it's necessary, your client could provide invoices or any proof that
Yes.
that's true?
Yes. Some of the pictures, or at least one of the pictures that I've sent after the hearing examination, has the gardener in the photo.
The gardener in the photo, but I wonder if it's a continued,
Yes.
regularly scheduled services, so if that's on the same day, then one could argue in between those days, let's say if it's every Monday and until next Monday, logically trash could accumulate. So that's what I'm trying to understand, if the client, your client would
Yes.
have, if the landlord would have any proof if it's necessary.
100%, yes.
Okay, all right, thank you.
Again, if during the hearing
That's
examination.
okay, sir. This is just question period.
Okay.
Anything else? Okay, all right, so you did a great job. Go ahead and sit down. Now we're going to do the deliberation portion, because there is no, again, tenant here this evening to speak. So you've spoken for the landlord, and now we're going to do our deliberation.
Thank you.
Appreciate that. I guess maybe we can just do a quick round. Oh, I'm talking to my commissioners now. Let's do a quick round of any legal questions or follow-up questions, and then we can do the deliberation. That's usually how we go. I had one more question for this appeal, which was on the actual appeal itself, which was filed by the tenant. I think it's page 26 of the packet. Yeah. Where does the tenant raise the cleanliness issue related to the walkway as part of the appeal? I see in here some discussion about the rent overcharge issue, but I didn't see where the tenant had raised cleanliness, or was this just a staff internal review thing and staff brought this up?
No, because the appeal is not explained very well by the tenant here, we had to interpret what they were actually saying, and we thought that the inclusion of the lease just meant that they were complaining again about the duties and responsibilities of the landlord. So staff tends to treat confusing documents liberally to not miss things.
Okay. All right, but I'm not missing something where this appeal doesn't raise cleanliness in any clear written form.
You are correct.
Okay. Okay, that was my question for legal. Any other questions people want to go ahead and Commissioner McCafferty?
I could use some clarification on, I guess, the responsibility of proof here. To me, I see the tenant saying that it's dirty, kind of subjective, right? But then I see no proof from the landlord that they are cleaning it, besides stating we are. Is the proof on the landlord in this scope to prove to us that they're cleaning, or is it more the opposite, the tenant to prove to us that the landlord's not doing it? Or is that not what I'm supposed to be thinking?
No, you're on the right track.
Okay.
You're looking again at, is there substantial evidence in the record to support what the hearing examiner found? The hearing examiner found it was clean. Staff is recommending reversal of that. And so if you were to find that it is not cleaned and it is a reduction of a housing or maintenance matter, it would be either one, because they kind of rebut each other, right? If one sways you one way, the lack of evidence might support that. But the burden would initially be on the tenant to prove that that is a reduction of maintenance or a maintenance issue.
Thank you.
You're welcome.
Right, Commissioner Kerpes.
Yeah, I just want to clarify that there doesn't seem to be any dispute over whether there's a gardener or not on a regular basis. That it's, even the tenant states in the original tenant testified that there is a gardener, but that he only blows the debris away. Remember, that's the issue. Like, he's not been able to use the water. So he goes and rakes, he blows, he does all that stuff. He just doesn't spray water. And that seems to be the big issue here. Would you agree, staff?
Yes, there is evidence in the record that there is a gardener, whatever title you want to give that person. I don't think that's as much a dispute. It's the what are they doing, and does it reach the level it needs to be for the tenants, for maintenance and housing?
Oh, Commissioner Copeland?
That's part of it. It was the cleanliness of the walkways, but the other part is also the maintaining of the plants and the greenery and so forth, which was also in the photos. So since we have to look at the evidence in the record, and we cannot base anything on photos that were submitted after what we have in the record, or new testimony or new evidence. If we did find that that was enough to say that the walkways were not being clean, the trash cans weren't clean, and the plants were not being maintained, if something has been changed since that, they can always apply for a compliance determination to prove that that's no longer the case. Would that be the process? Is that
That is
correct?
absolutely the process. You got it.
Okay, all right, thank you. That's it for me right now, Chair.
For this appeal, I want to try something different, which is I wanted to take a straw poll on one of the issues, which I suspect might not be, we might have consensus on right away, which is the rent overcharge issue. Is anybody on the dais right now thinking that that the hearing examiner got it wrong, or that we wouldn't follow staff's recommendation to approve on the rent overcharge issue? Because I just myself didn't see anything. That one was a pretty close, like, yeah, I'm not, I'm inclined to follow the hearing examiner and adopt staff's recommendation on the rent overcharge. Anybody else feel different? Okay, so assuming that's kind of out of the way, let's focus our conversation on the other issue.
Chair, before you move to another topic, on the rent overcharge matters, I asked the legal counsel, I don't like the idea to leave alone by itself, that there could be a MAR determination issue here, because if there is an overcharge, clearly there is a increase in the MAR. So we can't just ignore that there could be possible illegal rent increase. So one thing is to prove the actual payment in order to get the reimbursement for the overcharges. Another thing is if there is any illegal rent increase, that would increase the MAR. So I think at one point we need to, well, not at one point, I would recommend, as I mentioned previously, if the commission would support waiving the 6-month window for the tenant to refile for the purposes of determination of the MAR, and if there are overcharges occurred, if the commission agreed with that, I would agree with that. If not, so then the tenant can come back after 6 months and file a new complaint. So it's up to the commission, so I'm fine with either way.
Let's table that discussion, which I hear you, and we can talk about if we get there, making any exceptions to those rules. I'm not sure I'm on board with that just yet, but we can debate that, I think, after we talk about where people feel on, because it might get influenced by how we do on this other issue, the cleanliness issue. So I think we're going to have probably some different views on this, which is kind of interesting. Here's where I'm at, just personally, but I'm not really too hard in one spot, so I'm going to be swayed by what everyone else has to say. My initial thinking is a couple things. Number one, we don't have a tenant here tonight. That is a big factor for me. If you're going to file an appeal and these are really issues that are really, really important to you, you're gonna show up, or you're gonna have some message passed along why you can't be here. And it goes for both sides, and I'll be honest about it. If the tenant or landlord doesn't appear, it's not a good look, just as a general practical matter for me. Others might have a different opinion. Number two is I probably wouldn't agree with staff's interpretation of the exception to the 6-month window under these circumstances. I just feel like personally, when the hose issue got raised, this was part and parcel of that. I know we made, and maybe you guys can convince me otherwise, I'm not sure I was here for this other appeal. I'm really stretching my head to like remember this one. I know it was done like back in March of 25, but I just don't, to me, the issue of whether you have the ability to use water to water plants or to wipe water down a pathway is a really close cousin of how clean your pathways are and what's going on with the landscaping itself, because the water is used for the landscaping. And you can see from the pictures, like, this isn't some sprawling estate. There's a path, there's some landscaping. It's water's gonna affect it all. So I just have a hard time saying that the tenant couldn't have raised the cleanliness issues back with the other appeal. And I felt like when I read the record, that it was too far a stretch for me to say that exception applied. So I'm kind of inclined to not go with staff's recommendation and really to just go along with what the hearing examiner found. Now, I will say that probably the best evidence for the tenant on that issue is the pictures of poop, right? I mean, those are pretty bad. I'll say this, which is, unfortunately, that's not the first time I've seen pictures of poop. And I'm referring more to like cases I've had. Poop always looks bad. You can take a picture of a poop. It can be anywhere, and it looks, immediately people are like, you're gross, this is nasty. And you really don't have a sense for like, well, you know, okay, how often is that happening? Is that really just an anecdotal one-time thing, or do we have a fecal mess, you know? And there's no pets here on the premises, so now that makes it even more strange, because it's like, well, obviously another pet could come and do that. I don't know. We don't know the story of the poop pictures. They don't look good, so I'll admit that. But I'm not seeing how that, you know, it's substantial evidence to support what the hearing examiner did. So the hearing examiner presumably saw the poop pictures and then also saw the other pictures where I thought the path was reasonably clean. There's clearly like some jacaranda blossoms that were in one of the pictures, but it's like, come on, like when those things drop, it's messy everywhere. That's not a reduction in housing service. So if the hearing examiner said, you know, I looked at these pictures, I looked at the poop pictures, and on balance, I decided that there wasn't a substantial reduction. I think that word substantial is also kind of really important here. It's not like a reduction service. It's like, it's so dirty that we're gonna call it a reduction in service. And the hearing examiner, I thought, kind of said, no, I don't think that it's a substantial reduction, and I'm not so inclined to reverse on that. And I'm also really not inclined to find the exception that allows for the reversal in the first place. So that's where I'm at, but I'm sure other people are gonna have different views on it. So if anybody wants to volunteer, otherwise I'm gonna cold call.
I'll volunteer.
Okay, thank you, Commissioner Kirby.
I agree with you on a lot of those points. First of all, starting off with, I don't understand why the decrease either, or why we're allowing this to come in front of us now, or why we allowed it to be filed, because the decrease about water before was about lack of not having the water to now is cleanliness because of the lack of water, to me is the same thing. I think that's the point you were making. So I don't know how we got it here, but whatever, I agree. You know, if staff has to make a call, I'd rather have them err on the side of allowing it than not. So we are dealing with it. I still find it interesting. I don't understand. Staff doesn't provide any reasoning other than a blanket, we disagree, which I oftentimes disagree with the hearing examiner, but yet I'm often advised not to think about it, is that it's a reasonable person, not what I think. I consider myself a reasonable person. I don't think that it's that dirty. I mean, I think that things, yes, there's dirt. There is dirt that's been there for days, but it's not messy. Like all garbage cans have dust and dirt on it. No one wants to touch a garbage can, and these garbage cans don't look any scarier than my dumpster at my house. The leaves, I agree. All the comments you made, I won't repeat them. Types of leaves, I don't see any dead shrubbery, which again would relate to water. And I don't see any, exactly what we've just been talking about. Nobody wants to see poop on their front yard or on their steps, but water, spraying it off is not the way you clean that up anyway. So that's not the appropriate approach, even though most of us, maybe that's how we do handle it. So again, I don't see any, I don't see much of a call or a reason for determining this as a lack of service. And then I get into, like, let's say the majority of the council or commission does want to say that it's a lack of a service or a substantial decrease. The $30 value, I think, is extremely high, considering that the tenant for 20 some odd years, probably more, has had the requirement and has voluntarily done all the cleaning at the site. He says that that's what the facts show, is that the tenant has always been responsible for doing it. He and others have taken turns, changing the garbage, all that stuff. So nothing much has changed except for the water issue. So I just don't see $30 as being the right amount. I would go for the minimum if we get to that point, but that's how I feel about all the different factors of the case.
Great. I'm going to ping pong to Commissioner Topchian, and then I'll go to Commissioner Copeland.
Thank you, Chair. So, the first of all is, clearly it's the tenant's, the burden is on the tenant when the tenant files a complaint or an application for rent decrease, and this the legal counsel explained perfectly well. So now, and the tenant tried to meet that burden and provide whatever evidence the tenant had to support their argument. Now, when I'm reading the examiner's determination or analysis, where the examiner specifically says the walkways and trash cans, while a bit unsightly, do not appear to be unkept and are only dusty, or have leaves and similar natural debris on them. Tenant admitted that the landlord continues to have the property cleaned by way of leaf blower. This was supported by the statement from the landlord's attorney, which, confirmed that the service, the gardener comes once a week. And hypothetically, if the gardener comes on Monday morning, by next Monday, you expect that within 5-6 days, there will be some debris there will be some leaves there, some dust there. So we can't really expect that the property would be completely clean from any leaves, any dust, and it's impossible. And the photographs, the images that we have before us, they definitely show the property, as you, Commissioner Kerpis, explained. There is maintenance. There is no overgrown vegetation or dead leaves or branches that had to be removed. clearly the property is being kept in acceptable, I would say, conditions. So now, I don't believe that the commission can put a standard that, you know, the gardener has to use the water to clean the walkways or trash cans or something. I don't believe that's our job to set what type of standard or set a precedent that, okay, and next time the landlord, any tenant was gonna come file a complaint and say, hey, you know, the landlord is not using water to clean the yard or the walkways. So then, you know, in your prior cases, you guys established that. So I don't think we should set that type of standard for this type of services. And again, for a couple of reasons. Number one is that I see that the analysis of the examiner, I believe that this analysis are correct. Second of all, we have the statement from the landlord's attorney that the services being provided on a weekly basis once a week, and there is a tenant statement at the hearing, that meeting the landlord continues to have the service provided. And I would agree with the argument that basically if the rent is $500, $30 rent increase for this kind of really excessive to me. But I would actually even recommend not to support the rent reduction. I'm kind of leaning towards that, kind of at that decision. So, but it's up to the commissioners. I want to hear from other fellow commissioners. Thank you.
All right. Commissioner Copeland, and then I'll go to Vice Chair.
All right, thank you. I guess I'm going to be the other voice on this right now. While I understand the comments about cleanliness and, you know, leaves falling and so forth like that, there were dead leaves and brown leaves as well, which don't happen overnight or just in a few days. And plants seem to be drooping, dying, that kind of thing. So to me, the issue is if you have taken away the ability for the tenant to maintain the greenery and the potted plants and the other things by no water access, and then you aren't doing it either, or if you're just even cleaning the walkways, then you have taken away a service, even if it's just part of or one side of the cleaning the walkways and the trash can. Okay, if that's passable, there's still the other issue, and that ability for them to correct that issue was taken away. And we have a lot of potted plants and plants in my place, and if the gardeners don't happen to water them that week, well, certainly we can go out and do it. We have a hose. But if they remove that, put a cap on it, they're going to die. I mean, you know, you're taking away a service, and we don't have anything from the landlord showing that that's been remedied or that they're, other than what we have in the packet, which to me shows that that's what's going on. There's some neglect going on with that. So that bothers me, and I understand why this was a different issue. If you're able to take care of something yourself and then you're not, but they're not going to replace that service or that maintenance, then you can't do it and they're not doing it either. To me, that is worthy of some sort of reduction. Now, I also agree with the range on this is, staff can correct me if I'm wrong, 24 to 64, and staff recommended 30. I mean, I would be willing to go to the lower amount, the 24 on that, because of all the factors involved, but it definitely does not sit well with me that if you remove the ability to take care of these plants and then you're not doing it yourself, and certainly if that has changed, a compliance determination would remedy that. You know, come out, look at it, we are maintaining these now, they're healthy, whatever, even though we don't allow the tenants to do it anymore, we're doing it. But what we saw in the evidence packet, it was not happening to me. So I'm the other side on this. The rent reduction, for the MAR, to me, that was time barred. That's pretty cut and dried, I think. But this other issue, I understand why originally it was you took this ability away from us so that we can't keep it up if it's not being kept up, and now you're not doing anything to replace that, to remedy that. So to me, that is a removal of a service. You can't do it, and we're not going to do it. So that doesn't sit well with me at all, that part of it. The other part of it we can debate. Is it a little dusty? Is it a lot dusty? There's a little bit of leaves. I think we can debate that, and I'm okay with that part of it. But this other part of it, I think, is, I agree with staff on that, but I don't have a problem with reducing that to the minimum amount of 24. So that's my take on it, anyway.
All right.
Thank you, Chair.
Vice Chair?
I think I was stuck at the poop for a little bit, but then after looking a little bit closer, I think we can find the culprit in here. I don't know if you all saw there. Yeah, there's a cat very proudly sitting there, and if it's happy and photographed, then I suspect that part might be on the tenant. If that, if it's happy and sitting there, and those are the tenant's photos, then it probably belongs to the tenant. So I kind of went past that, but I do agree with Commissioner Copeland when it comes to the leaves and things, because it does look like they've been sitting for a while. So when you see that level of brown, and having lots of plants myself that I've taken care of, so I would support on the lower end, just to show that if they've, like what Commissioner Copeland was saying, if I'm not allowed to do it, but then you're also not doing it, then that would be a loss of service. So I would support doing something for that, but not on the higher end. I would support the low end.
Okay. I'm going to bounce back this way. Commissioner McCafferty?
Can I ask legal a question?
Please.
I'm torn on, is the access to water within this scope? Like,
Of the current,
right, like, does my decision, like, because I have one thought, bouncing off Commissioner Copeland's, saying that they're not able to clean because they took away access to the water, but my understanding before was, like, access to the water, like, I'm not thinking about it. Like, I'm just thinking in a scope of, is the property getting cleaned or not?
it's relevant. It's not the scope of your case here. The case here is the cleanliness, the trees, the plants, and the garbage cans.
Okay.
So that is the maintenance issue that is before you tonight. The housing service and the water access was in the last case, but it is a relevant factor, I would say, that there is no longer water access for the issue that you're considering today.
By the tenant.
Correct.
With that, I'm just viewing it as is it unreasonable for a hearing examiner to look at this evidence, these pictures. I could see how someone could reasonably say this property is maintained. It's dust, it's leaves, they build up weekly. Again, the pet waste issue, there's a pet lease in our packets. So that kind of puts on the tenant for me. So I'm looking really, I'm like not, the access to water for me is again relevant, but it's almost outside of the scope with my decision. So I would go with the hearing examiner on this one.
Commissioner Bass?
Thank you. I'm agreeing with the majority of my colleagues here and trying not to repeat too much, but the leaves that are on the ground look an awful lot like jacaranda leaves, and if in my neighborhood, when those sit on the sidewalk for an entire week, like if they come on Monday and they clean and they sit on the sidewalk until the next Monday, by Sunday afternoon, they look awful. They're not purple anymore. So this is a walkway. I can only imagine, even 2 or 3 days in, that's what that would look like. And, yes, it is the responsibility of a pet owner to clean up after their animals, but if they don't, and it's in a common area, it is the responsibility of the property owner to take care of the common areas and clean those up. I mean, I've had human waste in my apartment building, and I've contacted, because I don't want to clean it up, so I contact the landlord, and it's not mine, so I'm not going to clean it up. So I mean, I will say I contact them like, hey, you need to come clean this up, and they do. So, it is on the responsibility, but do you need to do that immediately? I mean, does the gardener do that when it's pet waste like this, when it comes back the next time, when they come back the next time? So what I see in here, I think I would have agreed with the hearing examiner, so I certainly believe a reasonable person would go there. So that's where I'm at with but I also am concerned that the 6-month issue did come up by Eric Fountain, and the only argument is that the tenant says, yeah, it meets one of these criteria. And so I really wish the hearing examiner would have included some argument in there as to how they found that issue, or maybe the landlord would have argued that at the hearing. I don't know if that happened, because in the hearing examiner's decision, it doesn't really even say much that the landlord's representative said in the hearing. So I don't know what the arguments of the hearing examiner were from the landlord, and that makes it hard for me to think that we should even get to this point. I think that the hearing examiner should have decided on the 6 months. So I would be voting to affirm the hearing examiner's decision, or to remand so they can decide the 6-month issue. But those are the two ways I would go.
Okay, well, I think we have sort of a sense. Okay, everyone, what I'm hearing is everyone agrees to adopt staff's recommendation on the rent overcharge issue. So that part is part of our motion no matter what. I'm hearing 2 commissioners, maybe a third, who are leaning towards adopting staff's recommendation, reversing the hearing examiner on the cleanliness issue, but potentially lowering the amount for the reduction in service. On the other side, I'm hearing maybe 4, possibly more, commissioners who are actually more inclined to just adopt the hearing examiner's finding on the cleanliness issue. So then I want to come back to, we could do, like, if somebody wants to make a motion in their way, we can see how that works. Not sure, or a straw poll. But the other issue is the suspension of the 6-month window to do another MAR analysis. Personally, I'm not inclined to do that. My gut here is just telling me that we should follow the standard rule, which is you got to wait 6 months. I guess partly I'm basing it on, I think that the rent overcharge going back to 1991 shows me that this appellant here just did not quite understand the time bar issue, and I'm not so excited about having another appeal to go back to 1991 again, or to do that all over again. So plus just my gut here, I'm saying I'm not inclined to waive on that piece of it. I don't know if I'm hearing, is anybody inclined to waive on the 6-month? You guys are. Okay. Oh, you're not?
I'd like to make a motion that I think will solve this all, I think.
Okay, you want to take the lead, Commissioner Kirby?
I'm gonna move that we deny the appeal and affirm the hearing examiner's decision in full. And the reason I'm not including the 6-month is because I think we're at month 5 already. And so I just don't want to muddy it. That's my reasoning.
Okay, so that motion is recognized. Is there a second?
I'll second it.
Okay, so with that, then we are going to do a roll call vote, please, on the motion. And legal counsel, are you okay with the phrasing of the motion and how it would relate to the resolution?
Absolutely.
Okay, so that's the motion. In a second, we'll do the roll call.
Commissioner Bass?
Aye.
Commissioner Copeland?
No.
Commissioner Kerpes?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Topchin?
Aye.
Vice Chair Goldman?
Aye.
And Chair Rory?
Aye. Okay, so that one passes 6-1 with the, and council, do you want to read the adopted resolution, or how do you want to handle that?
We are just affirming the hearing examiner's decision in full.
Yes.
So that's all I will say. We don't need to have any additional findings or anything special, because we adopt the findings in the hearing examiner when you affirm.
Okay, great. So thank you for leading that, Commissioner Kerpes. So with that, I have this read off that I need to do here. The motion passes. So if the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rst@weho.org, or you may request an in-person appointment online at weho.org under the services menu. Okay, so that concludes the 50/50 appeal. It is 8:15. Are people okay to plow through, or do folks want to do a break? If we don't break now, I think we should do a break before the presentation. That would be my suggestion. What? Does anyone, are you guys okay? How are you feeling? Okay, let's do 5. Let's do 5. It's 8:14. We'll come back at 8:20. Brief recess. All right, everyone. Thank you for that recess. We're going to go ahead and resume tonight's meeting. Our next item is going to be the appeal for D-5087. We're going to repeat the similar process we did before. We're going to have a report from legal counsel, and then for this appeal, we do have representatives from both sides, so they'll have an opportunity to speak after we do presentation from legal plus questions if there are any afterwards.
All right. So before we get started, I checked, and Chair, you and Commissioner Topshin were absent for the D4966. So you were correct. There was a reason you didn't remember the case. All right. So we are on to D-5087 at 1236 North Ogden Drive, Unit Number 3. The appeal in this matter is filed by the landlord. The issue before the Rent Stabilization Commission is a maximum allowable rent and rent overcharge matter. The tenant has lived at the property since November 16, 2024. Tenant filed a rent adjustment application on October 1st, 2025, and a hearing was held in November of 2025. Both parties appeared. The hearing examiner issued their decision in February of 2026, finding that the initial base rent and the current MAR are both $2,995.00. Second, that the landlord had accepted and retained excess rent starting on November 1st, 2025. That should be 2024. And the landlord must reimburse the tenant for all rent received in excess of $29.95 per month. The landlord timely filed an appeal arguing that the MAR determination is contrary to specific provisions of the Rent Stabilization Ordinance and/or state law. The facts pertinent to this case: the tenant testified that he moved into the property on November 16th, 2024. At that time, the monthly rent was listed in the lease as $3,300. An addendum dated the same day of the lease was listed the rent allowance of $305 per month for up to 12 months. The rent move-in allowance was also listed as a total sum of $3,660 to be applied over 12 months from November 16, 2024 through October 31, 2025. The addendum did state that the move-in allowance does not change the rent owed each month and that it was a one-time temporary rent allowance. Landlord testified that a new property management company took over in May of 2025. On page 3 or 115 of your packet, it lists out the rent payments made by the tenant. I'm not going to read them here, but they are available for you. In September of 2025, the landlord served a notice of change in terms of tenancy, increasing the rent from $3,300 with the AGA allowance of 2.25%, resulting in a new rent owed of $3,374.25. The hearing examiner issued their decision finding that the base and MAR rent for the unit were actually $2,995 and that landlord had accepted and retained rent in excess of what was permitted by law. The decision ordered the landlord to reimburse the tenant any and all rent received in excess of $2,995 per month. The landlord argues in their appeal that the treatment of temporary rent concessions in calculating the base rent is improper. The landlord further argues that the rent concessions that must be averaged over the term of the lease is the improper way to do that, which is what the hearing examiner did. And the landlord further argues that the RSO defines base rent as a contractual monthly rent established at the inception of the tenancy and does not authorize an averaging methodology. The landlord does not believe that the temporary promotional concessions change the monthly rent owed and does not reduce the base rent. The landlord also argues that this may conflict with Costa-Hawkins Rental Housing Act, which permits property owners to establish the initial rent at the start of the tenancy. All right. And so in light of the appeal, the commission must determine two things: whether the hearing examiner correctly determined the tenant's base rent and MAR, maximum allowable rent, and whether the hearing examiner properly ordered the refund of rent overcharges. Staff believes that the hearing examiner was correct and that the decision should be affirmed in full. As to the issue of the base and maximum allowable rent, sometimes we have base rents and maximum allowable rents that are far apart. Because this has only been a one-year tenancy, those are the same in this case. And $2,995 is what the hearing examiner found. That was the amount of rent charged minus the rent concession. And that is the proper analysis. Any rent concession that's offered reduces the actual base rent and MAR, because the definition of what the base rent is in, I will find it for you in a moment. But it is essentially what is actually demanded or collected. And so when you reduce the rent, you are actually collecting a lesser amount. And even if you put on the lease a higher amount, what you collect is your base rent and your MAR. And so with those rent concessions, it was $2,995 per month as the base rent and the MAR. And so the increase in rent would have been improper in this case. The Costa-Hawkins argument doesn't hold weight for staff. The reason being is that Costa-Hawkins does allow you to set the initial rent, but it doesn't say that the city has to define base rent a certain way. And so we can't tell them what to charge. Places like New York, a tenant moves out, they actually can't adjust the rent. So it's different than here. Here, the landlord, when a tenant moves out, can put whatever amount of rent they want if a tenant's willing to accept it. However, the city is permitted to define how base rent is calculated. And so that is what the city has done. We've defined the base rent as what's actually collected or demanded. And so in this case, staff believes that the hearing examiner's decision is correct as to the MAR, the base rent, and the rent refund matters, and recommends affirming the decision in full. Thank you.
Thank you for the report. Any questions? Okay, Commissioner Copeland. I'm going to go Commissioner Copeland first this time, then
Thank you,
Commissioner
Chair.
Topchin.
Yeah, I just wanted to confirm, you can correct me if I'm wrong about this, but what we're saying is that any part of a lease that's in direct contravention of the law is not enforceable. Does that include a local ordinance as well?
Yes.
In that? Okay. All right. That wouldn't void the whole contract, but any portions of it that were not legal could, okay.
Those would be not enforceable.
I just wanted to confirm that. Okay, thank you. Thank you, Chair.
All right, Commissioner Topchin.
Yeah, thank you, Chair. A quick one. The 30-day notice of increase effective October 2025 was based on the 30 in illegal MAR, whatever, which was determined. So it doesn't seem the examiner allowed that 2.25% based on the corrected MAR, 29.95. Am I reading it correctly? Shouldn't the rent increase be allowed, that 2.25 based on 2,995 rent?
So the rent increase is not technically before you. So what I see here is that the hearing examiner said the base rent is $29.95. They don't speak to any rent increases. Legally, that rent increase would be invalid because it's done on an improper rental amount. So they would need to reissue that. I'm not giving them legal advice. In general, they would need to reissue it with the correct $29.95 in there, but that we don't have those facts before us.
Yeah, I only brought this up because I saw that in your report mentioning that 30-day notice, and I thought, okay, so if we are saying the rent is $29.95, then logically the calculation should be based on that. But if you're saying it's not before us, then no further questions. Thank you.
You're welcome.
Vice Chair.
So are we saying that when they have these deals, rental companies, oh, you get this much off, according to West Hollywood rent stabilization, that those are not enforceable? I guess if you do it in that way, it sounds like you can't just bump
generally,
the rent up.
those are legal. It's perfectly allowable to do that, but it will, in most instances, reduce your base rent. And so many landlords don't realize that these can trip them up and lower their base rent. I'm sure there are crafty ways to do this that would not run afoul of the base rent issue, but most of the time, what you see, first month off or whatever, would similarly affect a landlord.
Thank you.
Okay, nothing on this side. So we'll move on to the hearing part. So I'm going to have the landlord's representative please come to the podium at this time. And sir, you're going to have up to 5 minutes to speak. Whatever time you don't use automatically goes to your rebuttal time. And after you speak, we're going to hear from the tenant, who's just going to have 1 5-minute block. But with that, you can go ahead and state your name, who you represent, and your 5-minute initial window will begin.
Can I just quick question before
Sure.
I start? Who's keeping time, just so I know?
Oh,
like,
the Madam
okay, so I can look at
Secretary.
you. Okay, thank you.
And if you need a time check, she'll give you.
Perfect. Okay, thank you very much. Commissioners, good evening and thank you for your time. My name is George Velasquez and I am here on behalf of the ownership for the property located at 1236 North Ogden Drive. I'm here to respectfully request the decision for application D5087 be remanded and reversed. While the decision was carefully reasoned, it ultimately relies on a framework that conflicts with controlling state law, specifically California Code, Civil Code 1947.2. It misapplies the city's own rent stabilization ordinance. At the center of this case, it is a straightforward issue, how a temporary concession is treated. The lease clearly establishes a contractual rent of $3,300 along with a separate time-limited credit of $305 for 12 months. These terms were transparent, mutually agreed on, and properly documented at the inception of tenancy. Under California Civil Code 1947.12, letter B, the distinction matters, and the statute reads, and I quote, "An owner of residential real property shall not, over the course of any 12-month period, increase the gross rental rate for a dwelling or a unit more than 5% plus the percentage change in cost of living, or 10%, whichever is lower, of the lowest gross rental charge for the dwelling or a unit at any time during a 12-month period to the effective date of the increase. In determining the lowest gross rental amount pursuant to this section, any rent discount, incentive, concession, or credit offered by the owner of such unit of a residential real property and accepted by the tenant shall be excluded. The gross per month rental rate for any owners offered discount, incentive, concession, or credit shall be separately listed and identified in the lease or the rental agreement of any amendments to an existing lease or rental agreement," end quote. Civil Code 1947.12 directs that concessions must be separately identified and, importantly, excluded when determining rent. Here, the lease did exactly that. By treating the net effective rent of $29.95 as the base rent, the decision collapses that distinction and, in effect, rewrites the agreement that the parties actually entered into. What this really means is two fundamentally different concepts. Contracted rent and a temporary promotion incentive are being treated as the same. And when that happens, the resultant base rent that neither party agreed to and the law does not support. This also needs to be viewed in the context of West Hollywood's own regulatory framework. The city has built-in safeguards designed to establish rent correctly at the onset. At the beginning of every tenancy, units are registered and the city conducts its own due diligence by reaching out directly to tenants to confirm lease terms, including rent, concession, and other material details. That process exists for a reason, to ensure the maximal allowable rent is accurately set at inception. If there were any disagreements about the contractual rent, that was appropriate time to raise it, not months later, and not only after a lawful increase was implemented. Allowing a retroactive recharacterization at the end of tenancy undermines the reliability of that system. It also established a precedent. Under this interpretation, any temporary concession can later be used to permanently reset base rent. That is not a reflective of the ordinance. It in direct conflicts with state's law requirement to treat concessions separately. There are other broader implications. Housing providers rely on the city's registration and verification process to establish lawful rent. Reopening that termination after the fact exposes owners to retroactive liability even when they fully complied at inception. This approach also raises concerns under Costa-Hawkins Rental Housing Act, which preserves the rights of owners to set the initial rental rate at vacancy. While local jurisdictions can regulate going forward, they cannot redefine the initial rate in a way that underestimates state law. Equally important, the rent stabilization ordinance itself does not require averaging or recharacterizing concessions Ordinance number 22-1177 did not amend the definitions of base rent. The interpretation here is administrative, not grounded on the text of the ordinance. For this reason, we respectfully ask that the Commission to remand the decision and apply a framework that, 1, honors the contractual rent as the base rent, 2, treats the concession as a temporary incentive as required by state law, and 3, preserve the integrity of the city's own registration and verification process. We respectfully ask for your consideration. Thank you.
I think we'll wait for questions. How much time does he have left?
30 seconds.
Okay, so let's go on to the tenant for a second. You can go ahead and have a seat if you're, and then you'll come up. If we have any questions, we'll ask him then. But, sir, I think you're online. I hope you can hear me okay. Samson, can you hear me okay? Oh, I'm seeing your picture. Can you hear me? Mr. Sampson? Yeah, now we can hear you.
Yeah, speaking. Can you hear me?
Okay, yeah, sir. So you get 5 minutes.
Okay, excellent. Yeah.
Go for it.
I'm going to keep it short and simple and sweet. That I think the gentleman in front of us has explained very quaintly that the base rent is defined by the city and it is the amount actually paid by me throughout the first year of tenancy, which was $2,995. I had never paid 1 penny above that throughout. I have receipts showing I did pay that amount. The landlord's ledger as well shows that I paid $2,995 consistently and thoroughly and with no issues. And we are in West Hollywood, and they define the ordinances and the laws set forth. So they ultimately have the jurisdiction to say what is base rent. So based on that, I believe that my true MAR is $2,995, and if the landlord does wish to increase my rent of the 2.25% as mentioned, he would have to do then so from I would assume if it goes within my favor today on, so giving me a 30-day notice, and that he cannot retroactively increase my rent from November, when the when I put the hearing in place. So he cannot back charge me for those 6 months, I think now, or 7 months, whatever it is. So just, yeah, that is all I need to say. I don't think it needs a complex explanation, and I'm going to leave it at that. Thank you so much for your time, gentlemen.
Okay, great. Thank you, sir. Is there any questions? No questions for you, sir. So I see you're already on mute. You can hang out and listen to the rest of the hearing. We're going to call the landlord back. You have your final 30 seconds, and then if there's any questions afterwards.
My only question comes down to the inception of tenancy. When City of West Hollywood probably reached out to confirm what the actual contracted rent was, why didn't the tenant at this time say, no, it's not $3,300 as noted, it's actually $2,995? If he believed that at inception, that's when it should have been done, not 12 months later. That's it.
Okay. Do we have any questions for the landlord? I'm not seeing any the same, so great. So you go ahead, have a seat. Thank you for your time. And we're going to get started with the deliberation portion, which will start with questions. I had 2 questions that I was just going to ask legal counsel to clarify. One was in the landlord's opening, he referenced the civil code section. So could you just maybe briefly address that from a legal standpoint, even if he repeats a little bit about what you've said before? And then I had a second question about re-educating myself on the limitations period for a MAR determination, how far back you're allowed to go. It doesn't apply as much on this tenancy, which wasn't very long, but I'm just trying to remember in my head. I thought there was a rule change about the limitations period on MAR determination, so hoping you can remind me.
Yes, absolutely. So as to your first question of the civil code, this is part of the Tenant Protection Act that was put into place several years ago by the legislature. It put in basically a statewide rent control, rent cap on increases. And the language in here is you can't increase the rent more than 5% plus CPI or 10%, whichever is lowest. To calculate that, you have to find the base rent under state law. However, the key distinction here is that it states in determining the lowest gross rental amount pursuant to this section. So that is for a separate rent analysis that we're not doing here, that we don't do here, because we have a separate rent control ordinance that sets forth our rent increases. So the requirement to remove any rent discounts, incentives, concessions, or credits applies if we were doing a Tenant Protection Act analysis with a 5% plus CPI or 10% analysis. That's not here. It doesn't say all rent discounts must be excluded or anything like that. It says in determining the lowest gross rental amount pursuant to this section. So it only applies to this section and not to leases that are under a city's rent control ordinance. So that is how we are able to interpret the base rent as we do, because this Tenant Protection Act didn't alter our city law. As to your second question, the statute of limitations, I want to look that up just to confirm for you, but I'll get back to you.
Commissioner Copeland, and then Commissioner Topchin.
Just wanted to confirm with Mr. Martz. So I understand what you're saying, that this new legislation was actually to put a statewide cap on rent increases of the 10% and so forth. So this is for, I guess, primarily rent-regulated cities have their own ordinance, and that would take precedence, but many cities do not. So the state said, okay, we're going to max it out at this statewide, but our local ordinance would take precedence.
Correct.
Okay, thank you. Thank you, Chair.
Yeah, just to echo what you said is this Tenant Protections Act is for non-rent control properties, as I understand, right? It's post-October, whatever, 1st, 7, 8, that's West Hollywood State also. Yeah, post-rent controlled, non-RSO units or buildings. So I think basically that argument really doesn't affect the West Hollywood's ordinance, doesn't change the West Hollywood ordinance, the TPA. As for the Costa-Hawkins, is there anything under Costa-Hawkins that would support the argument made by the landlord in regards to the rent concessions?
No.
So there is no really conflict with the Costa-Hawkins. Costa-Hawkins doesn't have any language that would mention rent concessions or something?
No.
Okay. So, and there is no argument that the landlord was denied the right to put a market rent. At the time when this unit was rented, when in 2024, I believe September 2024, right? Or November 2024.
November, yes.
Right, November 2024. That's when the landlord and tenant entered into this agreement and initiated this new tenancy with a new rent. So now our position has always been consistent that we go based on the actual payment of the rent, regardless of the lease, what the lease says.
That is correct.
That's the position. All right. Thank you, sir.
You're welcome.
Okay. Council's going to look up that limitations period question. And while we're doing that, we're going to do kind of now commissioner deliberation, I think. And I can kick us off with my thoughts, which are just that this was an appeal that was very legal based. The analysis was very legal based. We're dealing with a city ordinance and the city's interpretation of the civil code section applying to something different. This is not the first time this issue has come before this commission, even since I've been here. And I think that a lot of folks don't realize that in the city of West Hollywood, because of the way the ordinance is, that the rent concessions are going to affect your base rent from our calculations. And I don't think a lot of folks realize that, but that was the analysis then. It's the analysis today. And I feel personally like my hands are really kind of tied on this. Whether I agree with the policy or not, it's the policy, it's the regulation, it's been consistently applied this way. So I'm not inclined to undo that much legal bedrock. And so for me, I'm leaning heavily towards adopting the staff's recommendation and affirming the resolution. But it's largely because of all these legal issues which are kind of set. This body doesn't change the law or have the power to change the law. And this isn't even an interpretation question. This is just the law is this way in this city, and this issue comes up before, and the same thing happens over and over. The rent concession affects the MAR determination, and that's just the way it is in our city, at least in the cases so far that have come before this body that I've been on. So that's where I'm at. Commissioner Kerpes.
Yeah, I'd say precedent is very clear on this in the city of West Hollywood and most rent control cities. The other thing I'd say is that the tenant or the landlord was actually in a very fortunate situation this time because they caught it within a year rather than waiting several years for this to pop up, which has happened in some cases. I'm surprised that, but I won't go there. I don't think that there's any. I think it should be clear that we do support this this law as is because anything like that, even though it sounds like a great deal, like you're trying to incentivize somebody to move into, you're basically circumventing our laws. I mean, that's what it comes down to it. It may not be intended to be that, but that's what it is. And so that's why I don't have any qualms about this. This is very clear in our laws. Offering somebody a discount is because they won't pay the full price, which means that that's market. And that's what Costa-Hawkins sets up. That's what you're allowed to do. So to me, this is an easy one, very clear.
Commissioner Bass, I'm going to go to you.
Yeah, I think the ordinance is clear. I remember watching the city council meeting when they adopted this ordinance back in 2022, and I pulled up the staff report, and I think this is important. There's a paragraph in the staff report that says, while this approach may discourage rent concessions, staff believes it's consistent with the intent of the RSO and sound public policy. A landlord is offering a concession because it is what the market will bear at a particular time, and the base rent is intended to reflect that figure consistent with market conditions when a unit is re-registered. And they underline it's about what is actually demanded in the staff report. So this summarizes what I remember watching the city council meeting, that it was the intent of the council that our ordinance would take into consideration rent concessions in determining the base rent. And so I think it is very clear cut. That is what our ordinance demands. That was what the intent of the ordinance was, and that the city council, with legal advice, believed that it was consistent with state law. So here, rent concession was offered. It then impacts the base rent, and that determines the MAR. So I believe the hearing examiner got it right.
Commissioner McCafferty?
I'll affirm the hearing examiner's decision.
Okay. Vice Chair?
Yeah, I agree with what my colleagues have said and also prepared to affirm the hearing examiner's decision.
Commissioner Topchin?
Just a very quick thing. I don't believe that there is any ill intent by the landlord to circumvent the RSO in this particular case and charge a tenant extra. It's just the way the law is written in our city. And thank you, Commissioner Bass, for reading the specific section or the insert from that ordinance. So whether we disagree or agree with that, this is the law, and we had this before us in the past, and we have to be consistent with that. We were consistent with the law. Rent concessions may not be included in the determination of the cannot be included in determination of the MAR, and will go based on the actual rent that was demanded, received, or collected by the landlord. So, having said that, I will support the staff's recommendation. Thank you.
Commissioner Copeland?
Thank you, Chair. I agree with my colleagues on this one. I think it's, while I certainly understand marketing incentives and what the intent was, unfortunately, it's for the landlord, it's been established and very clearly that this is something that's in contravention of our ordinance, and the ordinance, the MAR establishes that the MAR is the initial amount that's demanded, collected, and received, which in this case was $29.95. So the only increases that are allowed after the base rent is established would be the annual general adjustments. And so I also agree with staff's recommendation to affirm the hearing examiner's decision. Thank you, Chair.
Okay. All right, well then with that, I'm going to propose a motion that this commission adopt resolution RSC number 26-705, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as application number D-5087. All right, we have a motion and a second. Can we do a roll call, please?
Commissioner Bass?
Aye.
Commissioner Copeland?
Aye.
Commissioner Kerpes?
Aye.
Commissioner McCafferty?
Aye.
Commissioner Topchin?
Aye.
Vice Chair Goldman?
Aye.
And Chair Rory?
Aye. All right, so that motion passes 7-0. If the parties have any further questions, you can reach the Rent Stabilization Division at 323-848-6450 by email at rst@weho.org, or you may request an in-person appointment online at weho.org under the services menu. And with that, we get to move on to the new business for tonight. So we are going to have item 9, which is a presentation on the current year 2025 rent stabilization and code enforcement process. And staff is going to be pulling that up.
Yes. Awesome. Thank you. Once again, I'm Leona Rollins, Rent Stabilization Manager for the City of West Hollywood, and tonight we'll be conducting a presentation on calendar year 2025 rent stabilization and code enforcement update. So last year, from January 1st, 2025 to December 31st, 2025, we received 8,360 contacts, with 4,514 of those contacts coming from tenants, 2,926 coming from landlords, and 920 coming from other parties, which consist of, property managers, real estate agents, and so on. The method of our community engagement means that we are receiving a bulk of our interactions via phone at 2,766. We received 1,984 via voicemail, which were promptly returned, of course. We also received 1,811 emails and 1,600 counter visits. And through our virtual appointments, we had 128. And now we're going to talk about some of the top inquiry categories in which we received. One of the highest, and continues to be so as well as in this new calendar year, is maintenance and housing services at 1,058. We received 910 inquiries regarding leases as well as the maximum allowable rent. We also received 779 general ordinance questions, just clarification on what this particular part of the ordinance means. We received 705 regarding hearing-related matters, questions about the hearing process, time frame, and so on, as well as 650 regarding evictions and temporary displacement. Some additional inquiry areas included inquiries, this came in bulk from our property owners regarding the annual registration fees at 571. We received 553 inquiries regarding our affordable and inclusionary housing program, 485 regarding other housing matters, and 445 regarding re-registration requirements. So we have a breakdown, and typically most questions are answered by our information coordinators and our admin team within 15 minutes or less, but typically when we're having more complex issues where people are dealing with violations of their lease agreement, unlawful detainers, hearing processes, we're spending a little bit more than that, and that's what impacts our workload at the Rent Stabilization Division. We did conduct 83 administrative hearings last year. They had multiple of tier resolutions. A lot of them were formal and resolved during the hearing process. And then in late October of last year, we did hire a city mediator who has been seeing a significant influx in mediation requests, which is why some of our appeals are withdrawn at the last minute. We are reestablishing our relationship with code enforcement and to ensure that as we're receiving habitability and substandard condition complaints at RSO units, that they're promptly addressed. And like this cross-department collaboration ensures that we have safe and equitable housing conditions for all of our residents in the city of West Hollywood. So as requested by our commission, we're going to establish a quarterly requirement where every quarter we'll present you with this data and facts to see we can see enhanced transparency within the community and also allow us to monitor trends. And I'm available for any questions or comments. Thank you.
Commissioner Kerpes?
Just a clarification question. So on, I think the third, where you're talking about registration, I think it was landlords' inquiries. You had, 571 annual registration fee questions, but then you had 445 re-registration questions.
Yes.
How are those differentiated?
Yes. I asked the same question when I started with the city. I was like, what is the difference? So the annual registration is when they specifically are asking questions regarding fees. So they're trying to assess what the fee is for right now, how they go by paying the fee, us walking them through the fee processing component. But the re-registrations, those specifically are when, for example, a tenant vacates the property and they have a new tenant moving in, they're required to re-register the unit, and that's what that count falls into. But yes, I had to clarify as well.
Thank you. And then one last question. I thought the 1671 for the counter visits was pretty high.
Yes.
So
we are very popular.
I was going to say, so do you see a decline or an increase or just constant?
It's pretty constant. On average, I would say in the beginning, like the first 10 days of the first 10 business days of the month, we see a high influx. People are passing out notices. They're having to pay their rent. They're looking for the various resources and services. So we see a high number of counter visits, averaging between 12 to 15 per day. But as the month goes on, we start to average between 6 to 8 per day counter visits.
Interesting. Thank you.
Commissioner Copeland?
I just had a quick question. This may have to be addressed elsewhere, but do we have any idea how many of these visits are then referred to, say, Bed-Stuy or somewhere in those first 10 days that people are concerned they've gotten 3-day notices or whatever?
Yes, so those that are getting like violation notices or also being approached with evictions, those notices are also required to be provided to our division. So we immediately send out information notifying them, hey, a 3-day notice has been filed with us, or a lawful detainer has been filed with us. So we send out a packet of information to let them know about the resources, which includes Bed-Stuy. But what we're going to be doing now, what we started in the month of January after I started, is that we're also keeping track of the number of unlawful detainers that we're receiving, the type of the reasoning behind those unlawful detainers, and how many people are actually being represented through our contract with Bed-Stuy. So you're going to see a lot of that data come forward when I do the presentation in the summer.
Okay, great. Okay, thank you very much. That's it for me right now, Chair. Thank you.
I had a quick question for the code enforcement part. Do you know what area of the city they're currently focused on?
So as of right now, they told me this too, because I was asking about our pilot program for risk stabilization unit. They are now moving, and I'm horrible with directions, you guys, I'm so sorry. But they're basically past La Cienega going towards here, if I remember correctly.
Moving west?
Moving west, thank you. Thank you, Kevin. Yes, moving west. And like I said, and it has been incredibly helpful because it can be things such as minor as them not having posting in the common areas regarding the RSO, or things as egregious as, flooding of apartments and things like that. So being able to work in collaboration with code enforcement is especially helpful for us because they can receive complaints that we don't necessarily know about, that we can intervene, and vice versa.
Great. Yeah, so as I understand it, it's almost like a rolling review process. So if they're somewhere around La Cienega and they're moving west, once they get to Doheny or wherever the westernmost boundary is, then they're going to restart on the east side and then do the whole process again.
And do the whole process all over again, yes.
Right. And that whole cycle takes almost like 3 years, or
that is correct, yes.
Right?
It is a whole cycle of that process because they're basically, instead of it being reactive, meaning they're only solely going out when they're receiving complaints, this is a very proactive approach that a lot of jurisdictions do not do. So they're able to address issues that maybe tenants are not aware of, and they also address issues that tenants can also be very fearful to bring forth to the city's attention.
And they give these buildings a heads up that they're coming, right? It's not
Yes,
like they
it's
just...
not surprises at all.
Right.
So in case, if a property owner or a property management team, okay, I have maybe like some minor issues I need to address, they're aware they're coming, they get some time to rectify those issues before the inspection takes place.
Right. So if there is an issue, it wasn't for lack of notice, so they can't, complain about that. But I would say for the next report, if it's possible, I'm just curious to know on that code inspection, what are some of the issues that they're finding? I think people would be interested to know just generally. You mentioned a few of them, but any
Yeah.
other detail that you can give as opposed to like counter questions or the phone type of inquiries? I'm
Yeah.
really interested in hearing what code enforcement, and it could just be like the most common issue
Yeah.
is, no place to deposit the rent check on the premises or whatever that issue is. I'm just curious what code is finding.
Yeah, and we could probably bring you like a top 5 to top 8 types of
Yeah.
inquiries because they're varying depending on month, but be able to paint a consensus will be ideal not only for you guys, but also for the community at large.
Right. And these are just last point. This is not just rent controlled building. These are all
Yes, code enforcement covers all properties throughout
all
the city.
multifamily
All multifamily properties throughout the
buildings
city.
are going
Yep.
through this
Regardless
process.
if it was
Yeah.
built 30 years ago versus 3 years ago. Yes.
Right. Okay. Oh, look, I say I sparked some more questions.
Just one, thank you, Chair. Thank you for this report. This code enforcement, the proactive inspections are only for the common areas, the building areas, right? So nobody goes inside the tenant's unit.
No entry into the tenant's unit unless the tenant sees the code enforcement officer and say, oh, by the way, can you take a look at this or that? Then they will actually go ahead and do that inspection in the interior of the unit.
So the inspection, the notification of the inspection, is it posted in the common area? Is it how the tenants will become aware that there is going to be an inspection? So then I will probably see the inspector and address my concerns at the day.
Yeah, so in the common areas, and typically they have like a little wall of fame. They're supposed to have all of our information listed there regardless of a pending inspection or not, so tenants are aware of what their rights and responsibilities are under our particular RSO. So it's a rarity when a tenant has to approach a code officer doing an actual inspection, because typically either the tenants are reaching out to code enforcement directly, or they're coming straight to our counter or visiting us via phone or someone to initiate their appropriate complaints.
I guess to clarify my question, so is there any requirement by the department or the code to that landlord to post a notification of the inspection in the common area?
As of right now, our regulations do not require that.
So the only requirement is to notify the property owner.
That is correct, yes.
So, which is the follow-up question is, I've always been an advocate for proactive code enforcement inspections inside the tenants' units, similar to what Los Angeles has, the systematic code enforcement program. Yeah, maybe this is a step further. A step forward to that type of inspection program in the future. Now, I don't know if we can make recommendations. I would definitely ask you to look into the possibility of maybe requiring the landlord to post this inspection notice in the common area, so that the tenants are aware of this inspection, so then they can, they can raise these concerns and be at home and see the inspector and talk to the inspector. Because if they are not aware of the date of the inspection or the time of the inspection, it's clearly, no one can invite them to the unit.
Exactly, yeah. And that's very similar to what they do in the city of Los Angeles with the SEP program, is that they're required to post notification in the common areas or serve notices to all the tenants, so tenants are aware if you do have issues, they'll be here at this day and time within this particular time frame. They can then invite them in and allow them to do full inspections of their units.
Right.
Yeah.
And in the future, I hope that one day, the code will require, will be updated somehow, or whatever we're going to call it. The regulations will be updated, or the code will be updated to have these units inspected on the proactive once every 3 or 4 years basis. Because, a lot of tenants are afraid of retaliation. They're not going to contact you. they're going
Exactly.
to call the code enforcement and report the violation. So they might continue living in some sort of deficiencies without addressing those things. So that's why the code enforcement inspections inside the units will be really beneficial, but we're not there yet. Maybe sometime in the future.
Moving in the
But
right
this,
direction, though.
right, but this is right. This is the right direction. This is a great program. I fully support it, and I thank you for the report. And I guess my recommendation is if it can be posted in the common area for the tenants to be aware.
Yes.
But thank you again.
Commissioner Copeland. And then
Yeah, I'm
Vice
sorry, I
Chair.
have a follow-up on that. I have a question for you. It's been a while since they came by my building, but we did get a notification that if any tenants want for us to come inside the unit, they left a phone number at the city that they could request that at the time of the visit. My question is, once they come through and they find these deficiencies, they notify the landlord. What is the follow-up process for that? Because how do we know that they've then complied? Is there another visit for a certain date, or what's the follow-up procedure?
It's my understanding in speaking with the code enforcement supervisor is that once a landlord gets notification of a violation, depending on the severity, they are provided with a particular amount of time to get into compliance. And then after that compliance date has passed, that's when code enforcement goes back out and conducts a follow-up inspection to ensure that compliance has been met.
Okay, so if it's something like they haven't painted the building, or there's obviously standing water, but
Yeah.
for the other issues, like no notices being posted, this is a rent stabilized
They're most
building,
likely
the
going to give them a
minor
minimum of
things,
30 calendar days to respond
about
to that.
30 days.
Yeah.
And someone does usually follow up on that?
That is correct, yes.
Okay, all right, thank you.
You're
Appreciate
welcome.
it. Thank you, Chair.
Great. Vice Chair.
Thank you so much for this report. It's
You're welcome.
really excellent. So I've actually seen some of the flyers on my block, and it seems like some buildings keep them up and some buildings do not. So I think it would be an excellent idea to have that requirement that because they're really helpful and they have the email and the information. They'll say an inspection is happening and you can call and have them come in. And I think what I notice a lot here is a lot of people just really don't know all of the rights that they have, and it kind of there's a saying that if you don't know your rights, you don't have them, right? Exactly. So I think it would be really excellent to have that posted, that requirement that that's also got to be posted for people. And then the other question, I was wondering if the code compliance, if they check heater installation. Because I have had in 2 different rent-stabilized apartments where I've called the gas company to check on the heater because it hasn't been working properly, and they two or three different techs from the gas company have said that they've come to multiple apartments, and it's a specific heater model that they've installed that's recessed into the wall, and it's not supposed to be recessed. And the danger is that if it's recessed into the wall, you can't test if it's venting properly, which means then you don't know if you have a carbon monoxide leak. And apparently a lot of the buildings have these heaters installed that way, I guess because whoever initially put them in just didn't know.
Yeah.
And so I'm wondering if that's something that is checked, because if the gas company is saying, oh yeah, I'm out here all the time for this, and I'm like, that doesn't sound like
That doesn't sound helpful.
Yeah.
Yeah. So yes, that is something that code enforcement would also come out and conduct an inspection. Typically, depending on the type of technician you get from SoCal Gas, they would either tell you to refer the matter to code or to the county health department, or they will actually tag the units themselves. So we've also had similar issue with other properties where they talked about the recess of the heater and they actually got red tagged. So it just really depends on the technician that you receive and how they actually take. But in any regard of that, I would immediately file a complaint with code just to have them look into it once you have an assessment by the SoCal Gas technician.
Oh, that's interesting. So after the SoCal Gas technician comes, you could then call code enforcement
Absolutely,
too.
yes. Because they would not only have to deal with, because as soon as, and it will also involve the risk stabilization division as well, because once for example, if your heater is tagged, that's a lack of heat, which is a reduction of housing service, so we will have to be involved in collaboration with code enforcement.
Okay, thank you for that. That's helpful.
Commissioner Bass.
I want to ask a clarifying question about these numbers. I had to reach out about a faulty rent increase, and I had follow-up questions, and then the follow-up rent increased notice was also faulty. So I went back and forth about 3 times. And do these numbers count every contact or just based on the initial outreach?
So yes, so typically what was happening in years prior, so I had to like do some cleanup of the data, is that if you can call as many times as you want to, we only count your inquiry in the initial count for these data points. The first time you call it, like for example, you call about a rent issue and then you have a follow-up question about the same rent issue, I will only count your data point one time, but there is a separate data set that counts every multiple issue, especially if you call with the same issue multiple times, because that warrants further investigation. But this is clean data numbers, so it only counts the first contact based on the first type of inquiry that you made.
Fantastic.
If that makes sense.
Thank you. No, I just wanted to understand how to
Yeah.
understand these numbers. The next thing, I just want to underline something you said in here, and that is that there is the demand for in-person engagement. And not only do I see that in these numbers, but I also just want to congratulate your staff. And my interaction with them and what I hear from my friends and neighbors that interact, the staff in the department is fantastic. Before you and through your tenure. And then the last thing I want to say is that this report and the one from the last meeting, I just am really glad you're with us, Ms. Rollins. Thank you.
Thank you.
You guys good? Okay, great. Everyone good? All right, so thank you so much. This is a receive and file, so we will do just that. I should have asked if there was any public commenters, but I know you would have let me know if there were. Okay, great. So with that, we can kick it back to Ms. Rollins for any concluding remarks from staff.
Oh, I have a lot.
You do?
Sorry.
Oh, good.
So I have some, let's start with all the great stuff first. So I will show you the flyer, but it's not in color. I'll work on that. But we are having next week the Holocaust Remembrance Day will be held on Wednesday, April 15th from 12 to 2 p.m. at Plummer Park and Fiesta Hall. And if you don't know where Plummer Park is, it's 7377 Santa Monica Boulevard. And this also came in from one of our commissioners. It's going to be the WehoMisca Festival, which is going to be held on Sunday, May 17th from 11 to 7, also in Plummer Park. I hope that everyone will join us because me and a lot of my team members will be there in support. And then I want to give you some updates on several items that you requested. So during the last meeting on March 26th, there was a request regarding the LSAC unit loss, as well as how does that impact our housing market with the inclusionary housing. So I'll be bringing forth a staff report at the next meeting for April 23rd. We'll talk about that in detail in terms of the 5-year from January 2020 through December of 2025, the number of units that have been removed through the Ellis Act, and as well as a number of inclusionary housing units that have been produced, and how does that impact our rental market. And then also one of the other items that we were just talking about is regarding the security deposit methodology. We are hoping to bring that forth at the meeting scheduled for May 14th, so be on the lookout for that. Thank you.
All right, great. Any questions? No, we're good. Do we have any concluding public speakers? Assuming no, as we pan. All right, so we'll move on to items from commissioners. I'm going to look down this way. Okay, it looks like we got it all out. Sounds good. So with that, this meeting will now be adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on April 23rd, 2026 in West Hollywood Park Public Meeting Room, Council Chambers. Thank you.
The Dyke March just brings people